Okay, fabulous. So welcome to all the members, and yes, the clerk and the analysts and all the staff and all the interpreters and everybody that make this happen. So thank you to everybody. Hope everybody's recharged from the break. This is number 15 of our meeting number 15 of the Subcommittee on International Human Rights. Today we meet to hear from Dr. Penelope Simons in view of our study of the role of the Canadian Ombudsperson for Responsible Enterprise. So to ensure an orderly meeting, I'd encourage all participants to mute their microphones where they're not speaking, address all comments through the chair. When you have about 30 seconds left in your time of questioning, I'll kind of flash this card that I think everybody's knows about, and I think that's it. So just for Dr. Penelope Cruz, there is interpretation available in the globe icon at the bottom of your screen if you require it, English or French. And also to the members, so this first session is going to go with Dr. Simons to 7:20. So and I'll try to kind of figure out the timings on our questions so that it's all even and fair. So now I'd like to welcome our witness for the first panel, Penelope Simons, Associate Professor at the University of Ottawa, appearing as an individual. Dr. Simons, I now invite you to make your opening statement of up to 5 minutes. You have the floor, Dr. Simons.
Thank you very much, Chair. Thank you very much for inviting me to testify before this committee on this really important issue. I've been working on issues of corporate accountability in the area of resource extraction for over 2 decades, and I was a member of the Canadian Assessment Mission to Sudan, also known as the Harker Mission, that was sent by Lloyd Axworthy to investigate allegations of grave violations of human rights that were perpetrated to protect the business assets of the consortium of which the Canadian oil company Talisman Energy was a part. I want to talk today about the right to an effective remedy. Canada has an obligation to provide effective remedies for victims of human rights violations, including violations that are committed by private actors such as business enterprises. And the right to an effective remedy is widely recognized as a fundamental human right. It's been enshrined in a range of core human rights treaties that Canada has ratified. It's not only a rule of customary international law, but it is an erga omnes obligation. What does that mean? It means it's owed to states, by states, to the international community as a whole. And the obligation to provide an effective remedy is an essential aspect of the state's obligation to protect human rights. So states not only have to respect and fulfill human rights, they also have to protect human rights. That means they have to take steps to prevent private actors, such as business enterprises, from violating or becoming complicit in violations of human rights. And where those violations occur or where they're alleged to have occurred, the state has a duty to investigate. And this includes taking appropriate steps through judicial, administrative, or legislative measures to provide an effective remedy, including where corporations are based within a state's territory or subject to their jurisdiction, and they engage in activities that have a direct and reasonably foreseeable impact on the human rights of individuals or groups in other states. And this obligation was recently recognized, as you probably know, by the Supreme Court of Canada in the Nevson case. Now, non-judicial remedies play a fundamental role in ensuring the right to an effective remedy. So states have to, as part of a comprehensive state-based system for remedy of business and human rights obligations, not only have judicial remedies, but also non-judicial remedies. They fill a crucial gap where a judicial remedy is not required, not chosen, or perhaps there's not a cause of action that relates to the substance of a complaint, or the complainant doesn't have the resources or the capacity to bring a complaint. Now, non-judicial remedies need to be effective in order for a state to meet its obligation under international law. So you can't just create a remedial mechanism. It also has to be capable of delivering an effective remedy. Now, in the case of CORE, the ability, or the Canadian Ombudsperson for Responsible Enterprise, the ability to engage in a credible, independent investigation of a complaint against a Canadian extractive or garment corporation, that is, the ability to ensure it has all the evidence before coming to a conclusion, is crucial to its being effective and to meeting this standard of an effective remedy. So Canada, with the current status of the core, is failing to meet its international human rights obligations in this regard. And the fact that the effective remedy aspect was also confirmed in the legal advice that was provided by Barbara McIsaac in her legal advice to the government, where she said that the effectiveness is actually, as it currently stands, going to be dependent on the cooperation of the complainant and the entity being investigated, and that this means the entities, the core's effectiveness may be compromised. And it will not only be compromised, but also making a finding of fact that isn't based on all the facts can be harmful because it will not reflect the full situation of the allegation. And this is also harmful not only for complainants, but also for corporate entities. So without the powers to investigate and to compel, in other words, to compel witnesses and documents, the core is just a replication of the Harper government's CSR counselor, which failed to ever resolve a dispute. And the only difference here is that it has a new name and a longer term. Now, this is also a reputational issue for Canada. Canada can't claim to be a champion of human rights when it fails to comply with its own human rights obligations and allows its corporations to be operating with impunity, and then also fails to provide effective remedy for those who are harmed by the latter's activities. So I'll leave it there, and I welcome your questions.
Well, thank you very much, Dr. Simons. Now we're going to move to questions from the members. We're going to begin with the Liberals with Anita Vandenbeld for 7 minutes.
Thank you very much, Professor Simons. And I'm very happy to see a University of Ottawa professor here as an Ottawa MP. And thank you very much for the work that you've been doing on this issue. I'm going to pick up on something that you said in your opening remarks that is actually surprised me, because most of how I have seen the evidence and the testimony about the core is that it's a good first step, that it's new, it is just now really starting to undertake the things that it's set out to do, but it's a good first step, needs to be improved. Your word was that it is actually harmful, and you've said that it's harmful not just to victims of human rights abuses, but you're suggesting it's also harmful to the corporations. And that's something that we have not heard yet. I wonder if you could just elaborate on that.
Absolutely. So if a body has is asked to investigate a complaint and it can't access the information, then it is going to come to a conclusion that is not based on the full set of facts. And this can be, I think, detrimental also for companies, because it may come to a conclusion that the company has violated or its responsibility to respect human rights or otherwise acted in a way that is harmful, when in fact it might not have done so. So it can be harmful also to the company.
What would be your recommendations then? Well, first of all, what are things that might be actually being done right at the moment? But what would be your recommendations in terms of how to improve it?
How to improve the core. So, I mean, I think the original plan was for the core to actually be an independent entity that could make credible investigations. And it was supposed to have the powers to compel witnesses and documents. And so this is how it could be improved, is to allow it to actually engage in investigations in a credible way and come to conclusions about a situation with all the evidence before it.
And you also spoke about judicial, administrative, and legislative measures that are under Canada's international obligations. I wonder if you could talk about where there might be some gaps in any of those areas.
Well, yes, thanks for that question. I mean, I think you mentioned in your first question that the core has been talked about as being a first step. It's a good first step in terms of addressing, by providing a remedy in terms of addressing that aspect of the issue, but it doesn't it doesn't. There's no legislation in place that requires companies to engage in human rights due diligence, for example, to prevent them from becoming involved in violations of human rights in the first place. We don't have effective kind of incentive mechanisms set up in addition to human rights due diligence obligations that would encourage companies to take those preventative steps, for example. But what we really need in Canada is an overarching legislative framework that can address this variety of issues, preventative measures and remedial measures, and not simply just remedial measures.
Okay, so the core is a good first step. It needs to have more powers, and it is one part of a much larger, set of policies and mechanisms that are necessary. That you're suggesting would also need to be improved and added to.
Exactly. Yes. No, that's exactly right.
Okay. How much time do I have left, Mr. Chair?
2 minutes.
Okay,
two and a bit. Yeah.
So I did want to ask on another line of questioning about the impact on women. We know, and I've worked in the Democratic Republic of Congo, and I've seen the direct link, and the women themselves have drawn a direct link between the mining activities and the companies and the human rights abuses and the sexual violence that women experience.
Mm-hmm.
I wonder if you could tell us if there are ways that we can, certainly with regard to the core, but also other mechanisms that Canada can use to ensure that there isn't an indirect link. We were talking about direct links when companies are actually doing something, but there's that indirect link between the militias and other groups that are battling over the resources, and then the resulting sexual violence that occurs. I wonder if you could comment on that too.
Yeah. Well, thank you. That's a great question. And I just want to first say that it's important to understand too that sexual violence does not only occur in areas of conflict. It actually is a risk that follows resource extraction, large-scale resource extraction everywhere. It doesn't matter if it's in Canada or in other countries. So sexual violence there's a high risk of that. And so that means that any kind of regulatory measures that are in place, if you put in place human rights due diligence, you have to ensure that is takes into account the gendered impacts of resource extraction, and that there is a risk of sexual violence in this context. So if there's a human rights impact assessment that's done, there has to be a gender impact assessment that is part of that human rights impact assessment. So the whole legislative framework would have to take that into account. And that would be the same, if the Corps is investigating allegations of something that's happened in another country, she would also have to take into account, the differentiated impacts on women, and particularly this risk of sexual violence.
Is that part of the Corps' mandate? Oh, sorry.
Thank you. And now we'll move to MP Chu from the Conservatives for 7 minutes.
Thank you, Professor Simmons, from coming to speak to us. I'd like to start with your governance gap. Concludes that, and I quote, and other non-binding governance mechanisms are incapable of systemically preventing human rights violating behavior by transnational corporations, or of assuring accountability of these actors, or recompense for victims of such violations, unquote. It also contends that home state regulations as a crucial role to play in regulating such conduct, unquote. Would you say that this actually applies very well in the case of CORE, and how if so, how would this apply to CORE?
Okay, so thank you, thank you for reading my book as well. So I think that's a very good question, but I think probably the first statement that you made does not say that legal mechanisms. I think what we were arguing for in that book is that we need to go beyond self-regulation, that self-regulatory initiatives are incapable of ensuring in any systematic way that companies do not become complicit in violations of human rights. And the core, I guess, sorry, and what was the second statement you read, though, that the home state has an important role?
Right.
Yeah. So yes, the home state. So what we were arguing in that book, and what we, I think is a really important thing, is that, if we're going to start to change, the human rights impacts of business, we need home states need to start regulating their corporations when they're operating overseas, and that would entail, as I said to the Honorable MP Vanderbilt, that you have a comprehensive legislative framework that ensures that there are preventative measures in place, but then also have effective remedial mechanisms for private actors.
Thank you. You might have already addressed provided with MP Vandenberg earlier, but what regulatory framework?
Point d'ordre, mon cher président. Oh. Après, venez de me dire que la connexion.
I'm sorry, the interpreter just said that the connection wasn't very good and that was poor. There was poor core sound quality.
C'est les interprètes qui vont pouvoir nous dire si
Can
c'est
we
réglé.
see about correcting that? Is it because of the way the mic is positioned?
Is it mine?
Mr. Chair, we're not sure if it's on Mr. Chu's end or ours. Perhaps I'll ask him to move his mic a little bit closer to his face, and we'll make another attempt. I'll continue to investigate.
Okay, Mr. Chair, I'm just going to proceed with the question. Members, please let me know, or Chair, please let me know if there's any connection problem or audio problem. My second question is, what regulatory framework would you propose in place of CORE, and what changes could be made to make CORE more effective? I suppose the second part of that question has been kind of addressed earlier, but if you don't mind expanding on that, that would be great.
Yes, I don't think it's an either-or situation. The core could play a role in any framework of legislation by providing, with the appropriate powers, an effective non-judicial remedy for this. But I think, as I said before, I think you need measures that prevent companies from engaging in human rights due diligence. I mean, you may or may not be aware, but there's a lot going on in Europe now where states are putting in place or contemplating putting in place mandatory human rights due diligence obligations for companies that are operating abroad. And this is something that Canada should definitely put in place as part of its framework, but also a range of different mechanisms that could incentivize companies, that could allow private actors to hold companies to account. So, better access to Canadian courts, but also bringing claims to a core with the appropriate powers, and also sanctions for companies that become involved in some of the worst violations of human rights, for example, such as those were being perpetrated in Sudan many years ago.
Thank you. Could you please, I'm glad that you bring up some of the examples that you mentioned a little bit, but could you please take a moment to elaborate on your experience in the Sudan studying Talisman Energy?
Okay, well, I could tell you a little bit about that we were sent there to investigate these grave allegations of violations of human rights, and we found, in fact, that the public security forces that were protecting the assets of the consortium, the Greater Nile Petroleum Operating Company, of which Talisman was a 25% shareholder, were perpetrating terrible violations of human rights. They'd engaged in a scorched earth policy. They were forcibly displacing people. They were murdering people. They were raping women. They were abducting women and children. They were burning villages and looting. So committing also violations of humanitarian law and international crimes.
So it's not a direct instruction by the company itself, but it was the contractors that they hired that are conducting this. Yeah,
it was the Sudanese public security forces, but in many cases of human rights abuse, it is security forces that engage in this, but that doesn't absolve the company of a responsibility to, ensure that those that they engage screened and have clear instructions not to engage in violations of human rights.
Appreciate that. Mr. Chair, how much time do I have left?
You've got about 20 seconds, so.
Okay, thank you.
Thank you.
Thank
so
you.
we'll move to MP Brunel Duceppe from the bloc for 7 minutes.
Thank you, Mr. Chair. First of all, can you hear me okay? Thank you for coming here this evening, Mrs. Simons. Your testimony has helped shed light on the violation of human rights committed by companies that don't take proper care when they work abroad. In the previous meeting, Mrs. Mellifire said that she was confident that she had enough authority and resources, but there were fewer than 10 people in her office, and she didn't say what her budget was. Am I offside when I'm saying that it's difficult to believe this because there are 200 mining companies working in Mexico alone? Do you share Mrs. Mellifire's optimism with respect to the resources that her office has?
So I guess I'd have to look at the full budget to understand exactly what resources she has. But I do agree that we are Canada's host to a majority of the world's largest mining companies, many of which operate overseas. There are a significant number who are operating, I think, as you point out, in Mexico, but also in other parts of Latin America and in Africa. And so it is important to have a core that is an ombudsperson's office that is sufficiently resourced so that it can undertake investigations of complaints. But the resources, if it doesn't have the powers to investigate, then it can have all the resources it wants. It needs those powers as well to compel witnesses and documents.
Bye.
But we talked about the ability to conduct investigations. Do you feel that this authority is essential? And if so, in your opinion, if the ombudsman had this power, would that have an impact on the human rights violations? If this power were, in fact, there, if the ombudsman did have this authority, what would that change in concrete terms?
Thank you very much. That's a great question. So I think one of the things that would change is that we would be provided with the Canadian public and also the government, public reports about that have been properly investigated in relation to allegations that have been made against Canadian mining companies. So we would know what the situation was with respect to those allegations. And so providing those public reports then will inform not only citizens, but also the government in terms of what other steps it should take in order to regulate corporations. And it would, I think it would provide a lot of very useful information for the government in that sense.
Merci pour cette.
Thank you for your answer. I agree with you, I think. And going back to what Ms. Meyerhofer said, she said withdrawal of government support was an effective tool. Personally, I am not really convinced about the effectiveness of this. Do you think that that's adequate?
In terms of sanctioning an entity, you're saying? Withdrawal.
Yes, the recommending that we withdraw government support. Do you feel that's adequate?
I think that she could also recommend other types of remedial action. She could recommend that a Canadian company pay some sort of remedy or that sort of thing. So, but and this is where the powers would be necessary, because it would be very unfortunate for a company if they withdrew support without having looked at the full facts because they couldn't compel witnesses and documents. So I think that, you know, it's in the company's interest as well to have a core with the proper powers here.
Et là, je vais vous poser.
I'd like to ask you a question that I put to other witnesses. It's important. A lot of Canadians think that Canada is a leader when it comes to human rights. We're not the worst on the planet, but if are we really as good as we're made out to be? In your opinion, how does Canada compare to other countries when it comes to companies working, their own companies working in another land?
Okay, so I think it's difficult to always like compare Canada, but Canada does have a problem in terms of its reputation with respect to its extractive companies operating abroad. You know, there have been different studies that are done that have, you know, documented different documented the human rights violations that have been associated with Canadian companies operating abroad. And, you know, there are a lot of Canadian companies out there. And so if they are not regulated, then it's going to sort of look bad compared to other countries that have fewer companies out there. But Canada does not have a good reputation. If you go to a lot of places in Latin America, Mexico you brought up, you will find that that Canadian mining companies do not make it easy for Canadians to go to those countries.
Rapidement, parce que je sais qu'il me reste.
I know I don't have much time left.
We'll move on in your next round.
Merci infiniment, Madame Simon.
Thank you, Ms. Simons.
We're moving to MP McPherson now from the NDP for 7 minutes. Thank you.
I'll try to use Alexei's 10 seconds to good value. Thank you so much for being here today. This is very, very valuable for us, and your expertise is very, very welcome. I come from the international development sector, and I spent a number of years in my career before politics working on this particular issue. And one of the things that I'm interested in is you had just spoken about the impacts on companies and the fact that a strong core ombudsperson is actually good for those companies that are acting with ethical behavior. I spoke to a number of representatives from the mining sector. I've spoken to representatives from the Mining Association of Canada, and they say that they have a framework, that they have sustainable mining standards already, and so that they don't need our core ombudsperson to be able to compel testimony. Do you think that's sufficient, and why or why not? Well, I guess I know your answer, but I'll
yeah, no, I appreciate the question, but I guess it goes back to, you know, allowing corporations to self-regulate. Of course, there are companies that have good business practices in this regard, but there are always the laggards, right? And the ones that, and so, you know, self-regulation over the, you know, we've looked at it over the last decade. It has been absolutely insufficient for in terms of preventing companies in any systematic way of not engaging or becoming complicit in violations of human rights. So I don't think that what the Mining Association of Canada has in place is sufficient. It's good that they do have these business practices, but it is certainly not sufficient.
And in fact, the good players or the good mining companies will be tarred with the same brush because of the behavior of the bad companies if we don't have a strong ombudsperson that can compel testimony and witness. Is that what you're saying?
Yeah, that's exactly right. They will be tarred with the same brush. And so it's you know, for companies that believe or are good business practices and you know, engaging in human rights due diligence and making sure that, you know, that any allegations are looked into or making sure that they don't don't actually commit violations of human rights, if they're actually doing that, then they have nothing to fear from a core that has powers to compel witnesses and documents.
Okay, and one of the other, I mean, follow guess on what the core ombudsperson had spoken to this committee about, power of naming and shaming, or the power of sort of these voluntary measures. But again, I'll just put it to you if you could comment on whether or not you think those things are sufficient to ensure that all Canadian companies are not wrecking the reputation of Canadians around the world.
Yeah, I absolutely think I don't think that they are sufficient, or that naming and shaming is sufficient. That's what we've had in place for many years. We have policies. We ask companies to align themselves to certain multinational or multi-stakeholder initiatives or intergovernmental initiatives, like the guiding principles, but they are not sufficient to prevent companies from becoming engaged and to ensure that Canada's reputation is protected as a protector and promoter of human rights.
Mm-hmm. And you spoke earlier today about the impacts on Canada's reputation and whatnot. Mm-hmm. One of the things that you also spoke about is the harm that this would cause companies. I've talked to a number of different NGOs or CSOs representatives who have said that they are recommending to their populations that they not bring forward their complaints to the core ombudsperson because it actually could put them in danger and there is no protection for them with the process as it stands. Do you agree with that? Do you have any comments you'd like to make in regards to that?
Yes, I do agree with that. I think that it is, it's not going, for somebody even to mount a complaint to the Canadian ombudsperson, it's not going to be super easy because it's going to cost some money, but the other thing is, I think that if it's not going to come to anything, if there's not going to be a full investigation with all of the facts, then it will not be worth their while. And you spoke about people who might be endangered, human rights defenders who are protecting it, or other people who might bring the complaint, there might be backlash against them and there aren't protections for them.
Mm-hmm. Yeah, no, and we know that this disproportionately will impact Indigenous people and women mm-hmm. and people living in situations of poverty. So I think that's something that we need to keep in mind. Very quickly, just to finish off, I'll just ask one question about Minister Ng's testimony when she came before this committee. She was very vehement that the NCP is very different from the core, that it is a very different thing, and that this is a much better situation. But I struggle to see how that is the case. If you could just take maybe a moment to talk about whether or not you do see where those similarities are, I guess, but more importantly, maybe where those differences are.
Yeah, I think that, so if the core, without the powers to compel witnesses and documents and to engage in investigation, is not that dissimilar from the NCP. The core has a mandate so it can advise companies, and I don't think the NCP does that, but the NCP engages in mediation. And a core that doesn't have power to compel witnesses and documents can only kind of settle disputes with the agreement of both parties, participating, providing information. So it's in no different a position than the NCP. And I think there is a lot of overlap, and that, the core, isn't different enough without its powers to compel witnesses and documents.
Well, and I know I am running out of time, so I will cede my time, but I want to thank you very much. Your testimony today is going to make our report much stronger, and I really do appreciate that.
Thank you.
Mr. Chair, I'll pass it back to you. We can't hear you.
Mr. Chair, your boom is up.
Oh, sorry about that. Yep, so we're going to move into our second round, and our second round will be 5 minutes of questions from each member. We're going to commence with MP Khalid from the Liberals.
Thank you very much, Chair, and thank you, Professor Simons, for your very compelling testimony today. I just want to take a step back, and I know that we've been studying this issue over the past number of meetings and exploring ultimately what I think the objective of the core is to prevent human rights abuses from occurring, specifically on behalf of Canadian corporations as they operate around the world. And, we look at core, we look at NCP, but as tools to use to lead to that prevention. And I ask perhaps if you can contextualize a little bit what the court systems and litigation of these companies in the courts, what role does that whole I guess scenario have to play within this model of prevention that we're trying to put into place in Canada?
Okay. Well, I'm glad that you're talking about prevention, because I think that's absolutely a key thing. As I mentioned before, we need to have measures like human rights due diligence in place to ensure that companies prevent. But effective remedies also play a role in prevention, in the sense that if you get a decision in the courts that holds a company liable for violating human rights and requires it to pay compensation, then that liability, that precedent, will have a preventative effect. Okay, the corporate accountability will have a preventative effect. With the core, a decision, sorry, not a decision, but a report of an investigation that finds that a company has in fact violated human rights, engaged in whatever type of harmful conduct, and gets that information out into the public and to the government, will also have a preventative effect, because companies will not want to be brought, before the core, as it were, in a complaint, just as they would not be interested in, no company wants to get sued, right, and have to go through the courts. So I think both of these mechanisms have the potential to have a preventative effect. If, in the case of the core, if it has the capacity to compel witnesses and documents.
Thanks for that. And so do you think that as it currently stands, the court systems would be a better, I guess, route to remedy versus what is the core currently?
Well, unfortunately, it's very difficult to bring cases to the courts. I've participated in a number as an intervener, and there's only very few cases that get to the courts. You have to actually be able to fit the harm into a particular cause of action, right? You have to have resources, you have to have a lawyer, all of that. It's expensive, it's complex, it takes a long time. So I don't think that it's an alternative to the core, to a core that has proper powers. But it is a complement. Judicial remedies are at the center of the right to an effective remedy, but they also require non-judicial remedies like the core with appropriate powers to engage in proper, credible investigations of violations of human rights.
Thanks for that. I really appreciate that clarification. And we've heard testimony here that the Office of the Core is very unprecedented in creating a space to find those remedies to hold companies to account. I'm wondering perhaps if you can guide us through other jurisdictions internationally that have put in similar offices or have led the charge on holding corporations to account that commit human rights abuses across the world.
Well, a lot of Western countries or members of the OECD have national contact points, which some of them are much more effective than the Canadian one because they actually investigate allegations. The Canadian NCP has always held itself, even though there's a lot of leeway for NCPs in terms of deciding how to conduct themselves. The Canadian NCP has always said, no, we're just about mediation. We're only going to resolve the dispute. We're not actually going to investigate allegations as to whether a company complied with the OECD guidelines. But I mean, I guess I would hesitate to say that the core is so unprecedented. I think if it has the powers to compel witness and documents, yes, it would be kind of a leading a beacon of light in terms of holding companies to account, and something that that we should have in this country, where we have so many extractive companies that are operating across the globe, and that do engage in human rights violations.
Thank you.
Thank you very, very much,
Yeah,
Professor.
thank you, Dr.
I appreciate
Simon.
that.
Yeah, we
Thank
went
you.
a little over time. We're just going to move over to MP Reid for the Conservatives for 5 minutes.
Apologies.
Well, thank you, Professor, for being here. I wanted to just start with the erga omnes obligation that you referred to. I'd never heard of this before, but thanks to Wikipedia, I now have 3 paragraphs worth of knowledge. And I'm left with the impression that while these are, erga omnes just means it's an obligation that is owed to everybody and owed by everybody. What I'm wondering is, beyond that, these are not enforceable in any form of, there's no special enforceability at this point. You'd have to create an enforcement mechanism for any kind of erga omnes obligation. Is that correct?
So I guess it's hard to, so erga omnes obligation is kind of higher level of customary international law. And it's an obligation, that is owed by states to the international community as a whole. Mm-hmm. Yeah. So what it does give is it gives standing to other states who haven't been harmed by a violation of an erga omnes norm to bring a claim, perhaps in the International Court of Justice. So it's not that you would have to create special mechanisms. It's just, it depends on, who violates it, what the violation is, and whether another state has would be interested in bringing a claim against Canada, for example.
And if a claim is brought, so imagine a situation in which, well, let's use a real case. There was the Nevsun mine in Eritrea. Are you familiar with that case, I assume? It's come up in this committee a number of times.
Yes.
And of course, it's gone to the Supreme Court. So let's assume that it's in Eritrea. That government is not going to bring a claim forward because, of course, the accusation is that a state-owned enterprise that was a contractor was effectively engaged in the use of compulsory labor. So some other state brings that case forward, and it's brought against Nevsun, or it's brought against Canada?
So I think, in theory, I guess if one state violates an erga omnes obligation, then another state could bring a claim in an international tribunal. But I think I just want to kind of sort of distinguish between a private party bringing a claim against a non-state actor, a corporation, in being able to bring a claim in an international tribunal like the International Court of Justice, which is at the UN or in The Hague.
Point d'ordre, monsieur le...
On a point of order, unfortunately, the interpreter has said that she's unable to do her work. So I think that needs to be checked out.
So the clerk has been checking it out. Clerk, if you could just give us a little brief 30-seconder why this is happening.
Sure. We don't fully know why it's happening. It's happened before to other committees in other rooms. There's no known solution for it, other than to have people speak slowly and clearly, and if necessary, have them repeat part of their statement or question. And this applies especially if anyone is reading off any piece of text, then especially speak slowly and clearly. But I'll be following up on this, and hopefully it stops occurring.
Thank you, and we'll try again. So I guess the best practice is to just speak slowly, clearly, and into the mic.
Okay. Now, was I speaking, or was MP Reid speaking at that point?
Alexi?
I can't recall.
Okay, so I think what I was saying was that there's a difference between a private entity suing or a private individual suing a corporation for violations in Canadian courts for something that happened in Eritrea, and say, Canada bringing a claim against Eritrea for a violation, an erga omnes violation, for example.
I wasn't wondering so much whether the complaint would be brought against Eritrea, because from our perspective, as Canadian policymakers who are trying to influence the actions of Canadian companies headquartered in Canada or traded on Canadian stock exchanges, what happens in terms of the liability of the country in which the extraction is taking place is not going to incentivize in the same way that if Canada itself were defended, it would have a different effect. You can see what I'm getting at here, I think.
I'm not quite sure I understand.
Well, what I'm getting at is this. If we want to create a situation in which Canada changes the rules under which its corporations operate, then it makes sense for Canada to be the one that is potentially suable for allowing its corporations to act in a manner that's unacceptable. Does that not make sense?
Thank you, MP Reid. I did add additional time for the time that we had to take out. So,
in all fairness, Mr. Chair, you added 30 seconds. I have a timer, and that took more than 2 minutes. So, if you don't mind letting her give the answer to my question.
Sure. If we can just.
Yeah. So I guess I'm still not. You're saying that if Canada regulates its corporations.
No, I'm saying that if it could be structured so that Canada itself, there's two participants here, right? In terms of nations, there's Canada is the headquarters for extractive companies. There's the country in which the activities take place.
Right.
A situation in which the liability is only on the company or on the country in which the extraction takes place leaves Canada or any other country which is headquartering a company essentially free from the kinds of remedies that can be sought out. And we're the country that has the functioning legal system. That's what I'm getting at.
Right. So I think then the onus is on us, and actually we have obligations under international human rights law then to regulate our corporations and provide effective remedies. So I don't think it's a question of, if I understand you correctly, of somehow bringing a claim against Canada. Canada, I mean, that could happen at the international level. And sorry if I'm misunderstanding, but I think here, if a corporation's operating somewhere, then they can be liable for violations of human rights. And sorry, I'm looking at the chair to see if I'm okay.
Yeah, we're kind of done. So if you could just conclude.
But I will say thank you very much for that, Professor. Much appreciated.
No problem.
Thank you. And we'll move to MP Brunel Duceppe now for 5 minutes.
Moi, je veux des 5 minutes comme.
I'd like 5 minutes like Scott. This happens all the time. Thank you, Mr. Chair. Earlier, you talked about Canada's human rights obligations pertaining to Canadian companies active in other countries. What obligation are you referring to exactly?
So it's an obligation to ensure that companies that are operating within Canada's jurisdiction are not making decisions and taking actions that can have, or through subsidiaries violating their rights, the human rights of other people, of people in other countries.
Excusez-moi, j'ai pas eu.
I didn't get the interpretation at the start.
Est-ce qu'on peut recommencer parce que j'ai pas eu la traduction?
I didn't get the interpretation, Mr. Chair. I'm sorry. I do speak English, but I would like to ensure that the Official Languages Act is applied.
Yes. So if the interpreter can repeat and.
En fait, regardez.
We'll put it back to 0, the timer back to 0, and I'll ask the question over again. Then we'll have good timing. Is that okay? You talked about Canada's obligations pertaining to human rights and Canadian companies working abroad. Can you specify what obligation you're referring to exactly?
I'm talking about Canada's obligations to exercise due diligence to ensure that Canadian companies that are operating in other countries do not violate human rights while they're operating abroad. So Canadian companies make decisions, they do a lot of things, and their subsidiaries may violate human rights in another country, or their contractors.
Est-ce que le Canada...
And does Canada respect these obligations?
Well, I think this is what we're all talking about, is that there, you know, if Canada were to put in place a legislative framework to require its companies to engage in human rights due diligence and then make sure that there are effective remedies, both through the courts and through a properly empowered core, then that would be getting much closer to Canada respecting its obligations or you know, complying with its obligations.
Et tantôt,
some colleague asked a question about prevention. And it led me to the next question. Those companies that commit violations, and is it all about the culture of the company that would lead one to enforce commit with obligations or not? You're the expert. Do companies commit human rights violations because it's cost effective, or what is this all about?
So I mean, I think you know, companies probably don't go out seeking to commit human rights violations, and some of them care greatly if, you know, their personnel or the contractors they hire or whatever become complicit or perpetrate human rights violations. So I think that, you know, companies need to have in place, and this is one of the requirements of the United Nations Guiding Principles on Business and Human Rights, that the responsibility of corporations to respect human rights includes that they undertake human rights due diligence, that they look at what the risks are to the people, not to themselves. They engage in they engage in meaningful consultation with local communities, and that they prevent and then, if not mitigate, the violations of human rights, right? So that would be what a company should do. They should put in place these internal processes, and this is something that European countries are actually going to mandate of corporations.
Là où je m'en vais.
Maybe where I'm trying to head is that if the Ombudsman had the authority that we would like to see it have, do you think that companies would act in the same way if they knew what the actual authority of the Ombudsman was?
So I think that it would start to have a preventative effect on corporate behavior if the core could properly investigate, had the powers to compel witnesses and documents, then it would have a preventative effect, and that would help to ensure that corporations engage in, you know, better practices through probably human rights environmental due diligence.
Thank you, MP Bernal-Duceppe. And now we're going to move to MP McPherson.
Money talks. Okay, merci, madame. Merci beaucoup, Madame Simons.
Thank you, Ms. Simons. Thank you very much.
P. McPherson, which will be our last questioner for 5 minutes. Thanks.
Thank you, Mr. Chair. This has been a very interesting meeting, and I always get the privilege of being the last person asking questions. So forgive me if I jump around a little bit. About whether or not judicial remedies was something that would be sufficient to deal with this, and I think you spoke about the idea that they were insufficient because they were very difficult for those people who had suffered at the hand of mining companies to access those judicial remedies. And I also think that is in fact why we put in the core ombudsperson, or why this government had put in a core ombudsperson in place to start with. I'm just wondering if you had any more comments on that, about the reason for core, and I guess the fact that judicial remedies were always seen as not being sufficient for that.
Mm-hmm. Yeah, judicial remedies are, of course, central to the right to an effective remedy, but I think, as you mentioned, and as I said before, they aren't sufficient too, because not every set of facts can be a tort claim, right? And so harm that is caused will not be necessarily be remedied through the courts. Plus, there are all the other barriers, right? And it's very difficult to bring a claim also because many the companies can bring a lot of motions to try and have the claim dismissed before it gets to the merits. So having a core allows for investigation of complaints that would not be brought to the courts. We get a public document that comes to a conclusion about what happened, and it would be, if it had the powers, it would be a good sort of remedy alongside the courts, which are not sufficient in this situation.
Well, and I guess following up, I just asked a little bit more clarity on one of the questions that my colleague from the block had asked. So we had heard from Export Development Canada about the what they could withhold from companies who weren't acting appropriately, what the core could withhold from companies that weren't acting appropriately. And I guess I'd like to know, you spoke about how if we did have a good core ombudsperson, that they actually would make a change in behavior. Do you feel like the sanctions or sort of the disapproval, I guess, of either EDC or the core ombudsperson is sufficient to, like, do you feel like companies actually really care about whether or not that is withdrawn?
For some companies, it will be important to have that withdrawn, but it's important to remember that the core can only recommend to Export Development Canada. Okay, the Export Development Canada has to decide itself that it's not going to provide funding to a company. So that's a problem, and it's only going to hit certain types of companies. Like there'll be other smaller junior mining companies, for example, that won't necessarily be getting export development money necessarily when they're operating overseas. So it's not sufficient. It's a start. It's something that's important to have in place, but no, it's not enough. And I think there have to be other sanctions.
And one of my big concerns, and one of the things that I've seen all the time, is that companies change their names, they use subsidiaries, they avoid being able to be sort of held to account through some of these mechanisms. Now, you had talked a little bit as well about what was being done in Europe and how some countries around the world are doing a much better job of holding their companies to account, ensuring that their companies are going beyond the bare minimum to ensure human rights are being protected within their supply chains, within their operations. Can you just very quickly, I know we only have about a minute left, but could you very quickly talk about where you've seen great examples, which countries we could be looking at, which countries this subcommittee should be looking at?
So I think the first country would be France, that has in place this duty of vigilance law that requires companies over a certain size to take steps to ensure that they have a vigilance plan in place to make sure that their subsidiaries and other contractors and other entities in the global supply chain do not violate human rights, etc. So that's important to look at. But also Germany is looking at mandatory human rights due diligence laws, because they basically gave companies a year or maybe a bit more for 50% of them to voluntarily engage in human rights due diligence. That didn't happen, which was unsurprising. And so now they're legislating, or they have some legislation right now going through Parliament on mandatory human rights due diligence. The EU is also talking about this issue as well at an EU level.
Wonderful. Thank you so much. Thank you for your testimony.
Thank you, MP McPherson, and thank you, Dr. Simons, on behalf of the entire committee. We appreciate you've taken the time to appear here before us. And
before you let
yes,
Professor go, could I make a request to the professor that she forward the information she has regarding France's model? I suspect it would be very helpful.
And Germany.
Okay.
Okay, thank you. Some more homework there, Dr. Simons. Thanks for doing that for us. Okay, so members, we're going to suspend now, and we'll be coming back in camera for committee business. Thank you.
you.